today, we will explore the topic of the investigation of judicial misconduct with the presentation of a few example cases that demonstrate investigation tactics and highlight some good practices, and in particular can illustrate to the audience some intriguing aspects in the investigation of judicial misconduct, such as how to produce evidence while safeguarding judicial independence or how to deal with media coverage. We have received many comments from participants who are interested in this topic, and therefore we decided to dedicate the second webinar to it. So we are delighted to have today Mr. David Sachar and learn during this lecture from his extensive experience of more than 10 years working at the Judicial Discipline and Disability Commission of the state of Arkansas in the United States. He's currently serving as the executive director of the commission, and he's also an advisory board member of the National Center for State Courts. Previously, he gained experience as a litigator and prosecuting attorney in the United States. Again, the final reminder, please keep your cameras and the microphone off. And later, if you have questions for our presenter, also please use the chat function. We will have his presentation, and then Mr. Sachar has agreed to answer to as many questions as possible from the audience. So now I'll welcome David, Mr. Sachar, and thank you very much for being with us today. David, the floor is yours. Thank you.
All right, I think I'm set now. Thank you very much for having me. It's a incredible honor to be able to present at this webinar, and certainly given this subject that I've been involved in for 13 years now, almost 8 or 9 as the director and several others as deputy director. I'm the head of a state agency here. I will refer to judicial conduct commissions or JCCs, but really what we're talking about is any disciplinary body that is essentially looking at ethical misconduct or judicial misconduct. In this case, we have, just for overview, we have a group of 9 commissioners that we try cases to as if they were jurors, and we have 3 panels that work with investigations that are separate, and they will direct investigations that happen. They are made up of lay people, judges, and lawyers, and we'll talk about that a little bit as we go through. I want to start with a quote. If we have a quote that I have here to kind of start us off, and that is, "All the rights secured to the citizens under the Constitution are worth nothing and a mere bubble except guaranteed to them by an independent and virtuous judiciary." That quote's remarkable, but it's also remarkable because it came from the head of the executive branch. And I think what we're seeing in the world today, particularly on probably 6 continents, is the struggle to support the rule of law and attacks upon the judiciary. And certainly to have that kind of support from the executive branch is a nice thing to have. It's also necessary. But we do see that the encroachment upon an independent judiciary, which puts judicial conduct commissions on a fine line. How are we going to look into or look over the shoulder of judicial officers without interfering with their decision-making independence? And that's something that we'll talk about as we go through. It's a very broad subject. I've got an outline that was given to me, thankfully, by the Global Judicial Integrity Network, UNODC staff, who have been wonderful. I'm going to try to hit all these. Obviously, 9 questions. It's only a couple minutes per. So I will give you some general statements, and I will give you some resources that I think would be helpful if you want more information. And then if you have specific questions, I'll be here to answer them. So that's, again, whatever I can do there to help. Let me talk about a couple cases real quick. I know it's hard to do case studies, but they're so important. And I think one thing we've talked about even on the training aspect of judicial integrity is how important case studies are to know what factually happened, as opposed to broad principles, which are harder to put concrete facts behind. So a couple cases I'll talk about, and I won't go into too much detail, but they're public and they're available. The links are available to you to see what actually happened. But one of them that I will reference, just so you know kind of what it was about, is a case called Bachman. And he was a district court judge. It's a sextortion case where he was using his position to invite young men to be on a special probation program. The probation program was not that. It was actually an invitation to come to his house, where they found themselves in the awkward position of being propositioned by him. He took advantage of that. Several of them would get in trouble again. He would exchange either photographs, corporal punishment, he would spank them, or sexual favors in exchange for lessening their fines or paying them money. Another case was a sextortion case that we handled quite quickly, where a judge called Parker was exchanging release from jail with young women. There were many of them up there. There was also some drugs involved in that case. A case called Maggio. This one also made national and international news because it involved a South African Academy Award-winning actress from Hollywood, and so that made a lot of news, as you could imagine. He disclosed information about her private adoption online. When we looked into the statements that he had made online, the other statements he had made, there was 3,600 of them that were misogynistic, racist, otherwise offensive. So not only did we have him disclosing private information, we had a lot of comments by him that were not befitting of the robe. And he used a pseudonym, but it was Go Judge. So, and then he continually talked about how he was a judge in Arkansas. So he kind of revealed himself as well. There was a case where the Arkansas Supreme Court was reviewed by us, which is, again, pretty remarkable. We are constitutionally independent, so we are actually have authority over the Supreme Court for misconduct, where whether they were delaying in a politically charged case on purpose to avoid issues with election, because we elect our judges here. And so we had to look at that. That was on the same-sex marriage case. So we had to investigate that, which was pretty interesting. We had a case that's a tragic death of a judge's baby. He left the toddler in his car while he was in court. The toddler died from heat exposure. That obviously made for an incredible public outcry. Many people wanted him to lose his job and go to jail. Many people wanted him to be left alone because he'd gone through a personal tragedy. We're stuck in the middle and had to do certain things, in which case we waited for some criminal action to see what would happen with a criminal case. And then finally, a case where I might get into a case where a judge punched his wife's lover at a Walmart. So that was an interesting one as well. So I think from there, we'll go on to the first part of our first question we have, which is what are the barriers to uncovering misconduct? Obviously, a couple things I wanted to mention in particular is you've got to have a properly equipped Judicial Conduct Commission or disciplinary body. That means funding, that means staffing. I know that we're not the only country in the world that will create a regulatory agency and then fail to equip it and act like we're doing something good. We're not if we don't equip it. So thankfully, again, we're able to do our job. We're a small agency here, but nevertheless, we do have that equipment that we need to be able to do so. That includes offices, staffing, computers, etc. Another barrier that we have are that witnesses are reluctant to complain about sitting judges. And I know, we're not the only place where when you get to certain areas of the state or country where a judge is a very powerful person and you don't want to be the only person complaining about them or a person who the judge believes is trying to affect their career. This is something that is very difficult, but it requires a lot of skill on behalf of my staff. And when I was deputy director as well, we would, obviously have to find protections. We find those in our rules. We find ways to keep their identities secret as long as possible, but we still have to be transparent with the judge and with the public. I think there's some reluctance in the judicial community to accept a disciplinary body, and that's natural. You're worried about political consequences. You're worried about a body that might look at your decision-making process. And however, one way that we've been able to bridge that gap is to do a lot of judicial training. So we offer our services to train, to help judges stay out of trouble, to train new judges when they come on the bench. There was a couple years ago where I think I spoke 24 times in 1 year to different groups, including a lot of judicial groups. So we speak quite a bit on different topics. We also are open to advice. So if judges call us and they want to stay out of trouble, maybe they have a business dealing and they want to make sure that business dealing will not cause major issues with recusal or disqualification later on. Maybe they have something they want to handle with their family. They want to make sure that doesn't come across as them abusing their power. And we will actually talk them through that. Of course, there are also political questions we have to talk to them about because we do elect our judges in Arkansas. A couple resources for you to look at. Obviously, I just talked about a case involving sextortion, but the IBA put out a report in the International Bar Association in 2019 on sextortion, and it's excellent. It has a lot of good resources for you. I recommend it, and obviously some of those reluctant witnesses are going to be the most reluctant in a case involving some sort of sexual harassment or sexual misconduct. Secondly, the Global Judicial Integrity Network put out the Gender-Related Judicial Integrity Issues report in 2020, actually in Doha when we were there just a couple months ago. It obviously talks about judicial integrity issues involving gender-related misconduct. However, it has an excellent section on creation of judicial conduct commissions and how they operate. So that's something you might look at as well. As far as techniques, so again, some of these will kind of meld together as we go through. Typically, we use the skills of an auditor, the skills of a interrogator. Those kind of things are necessary. We have to take statements, we have to get documents, we have to do things like that. I think a thorough investigation behooves everybody and the public as well. We have some judges who have investigated, including the case I mentioned about our own Supreme Court, where some of the judges were happy that we were doing a thorough investigation. That way, when they are cleared, they can say, hey, this was not a whitewash. This was not just a minor investigation. They looked at this really hard and found nothing wrong. So I think a smart judge who's being investigated understands that a thorough investigation helps everybody. We get documents from all sources. And one of the things I've always taught any lawyer who has worked for me is when you first get a file, think of all the documents you could possibly need and get them. We have subpoena power. We have the ability to use the Freedom of Information Act in America, and in Arkansas in particular, where we can get access to public documents. But there's also other ways to get them. With social media, you have to be careful. You have to be ready to put out a preservation letter. It is not easy to get to know all the legal wranglings that come with social media platforms. Thankfully, I have people who I can talk to at our Attorney General's office to help me understand. For instance, how do I even address a subpoena to Facebook? How do I even tell Twitter that I want them to preserve something? All those things are available if you network with the right people, and that's certainly been something we've been using. We also use special techniques for cases with court as staff, court staff as witnesses, or the sexual cases that I mentioned before. One example, we had a judge here who was running a probation program out of a private company that he then had money go back to his own court, not into his pocket, but to benefit his court system. And it was just this alter ego he created. In that case, the staff members were reluctant to testify against their own judge. So what we did is we served them all with a subpoena at the same time, openly and notoriously. So they all knew, I've got to give a statement under oath, and so is everybody else here, and I don't want to be the one that doesn't tell the truth. And so it made it a little bit easier on them all to know, I've got no choice. I'm going to tell the truth about what happened. Again, group sessions with investigative staff, that's just a personal thing that I enjoy, is the opportunity to get with my staff, go over all our cases, and I think you'll find that different people have different takes. They'll come up with different thoughts about what could possibly be done in a case. And those sessions we do about once a month or every other month, really bring us together to come up with new solutions. As far as establishing an independent body with clear reporting, I would spend a lot of time on this if I could. I really enjoy talking on this subject. I know that makes me strange, but I do want to kind of direct you to that resource from the Global Judicial Integrity Network, because I think it's pages 50 to 66 I mentioned on there. it's going to talk about best practices. If you can be constitutionally independent, that's the best way to do it. If not, part of the judiciary, but with a proviso that if the Supreme Court needs to be investigated, there's some way to do that. We do a 3-3-3 type, which is 3 judges, 3 lawyers, 3 normal people, and they're appointed by a bunch of different political officers. So you can't just call the governor or call the Supreme Court and try to affect a case. It would be very difficult. Certainly when it comes to selection, multiple groups, staggered terms if possible. You might want to have geographic or diversity requirements in there as well. Jurisdiction is really the most important thing, though. What does a Judicial Conduct Commission get to look at? Well, it should be clear that they cannot look at appellate issues. That if it's clearly just dissatisfaction with results, then that does not come to our jurisdiction, and those are dismissed. It should involve just acts on the bench in your official capacity. It should involve the same aspirational standards that we see in the Bangalore Principles. Those are the kind of jurisdictional cases that we handle. And then also off-bench behavior, if the private life of the judge, if that behavior is affecting the reputation of the judiciary, the independence of the judiciary. We also have another proviso that I think is interesting and is a common complaint from some jurisdictions. That is, a judge can resign, for instance, in the federal system in the United States, and they have no jurisdiction over that judge anymore. Well, that's an easy way out for a lot of judges. Plus, it can lend itself to some political shenanigans. You could imagine someone could resign to avoid an investigation and then have their politically powerful friends appoint them to something else a little time later. Well, that's not something that I think the public looks well upon, and it's important. So after they're off the bench, even if they've resigned, why would you do that? Well, there's a couple reasons. And Bachman, he was going to be done as a judge regardless of what happened in our sexual abuse investigation. But we wanted to continue with it for a couple reasons. Number one, we can get a declaration that he's no longer eligible to be on the bench ever again. Removal from the bench in Arkansas means you're no longer eligible. Secondly, it's important that the victim's story be told. It's important that there be an opportunity for the victim's story in that situation to not just be buried because the judge resigned before the end of investigation. And thirdly, for transparency. Otherwise, the public has no idea what happened or why that judge resigned. There's some good resources. Again, I like that article. I think I gave a link to the staff on from the SMU Law School on the history of judicial conduct commissions in the United States. It has a little bit to do with President Taft, who went on to be the Supreme Court Chief Justice as well, and a little bit about the sport of baseball. So it kind of how we got these conduct commissions during the early 1900s when the ethical movement was coming through the American Bar Association and others. Let's talk a little bit about producing evidence. Obviously, just like you would in any type of investigation, but ours are confidential at the initial investigation phase. And what that does is allows, just like a police investigation, it allows you to investigate at that initial phase without it being just blown up in the press because there's constant talking or there's all the documents are public at that phase. So it gives us a short period of time to investigate to start where the judge is not at unfair risk of mere allegations becoming the story. The staff and the fact-finding body, which is our panel, they're bound by confidentiality. So we don't talk to the press, we just do our jobs at that point. We might acknowledge that there is an investigation just to give the public that information, but that would be about it. Now, when we're done, we're going to produce a final product. And whatever that may be, it could be a dismissal, it could be a sanction, agreed upon sanction, or it could be public charges where the judge did not agree, but we're going to go to a trial to determine. All that stuff is available to the public. Public access, if the case goes on trial, means that the public can sit in the audience and watch the trial occur. Some states don't do that, so there's a little difference in how things happen in the United States. As a resource for that, I would look to the National Center for State Courts, and there's a link that I sent as well. That link will show you charts in the United States, at least, of how commissions are created, what their composition is, how many lawyers, how many judges, and then it also will tell you like the different rules that they have and when their confidentiality ceases to exist, just to show the difference. I'm quite happy with the way that ours was created and the way our operations occur. I think Arkansas, my state, benefited because we were late to the game. We were, it was the late 80s before we established a JDDC, Judicial Discipline and Disability Commission, by constitutional amendment. So we got to look at the other ones throughout the United States and kind of pick some best practices. However, all the way up until when I was here to start in 2007, 2008, we did make adjustments and change some of that, which again is kind of technical. But if you have questions about how we operate, I will certainly be happy to answer that. Media coverage and social media. I did not think I would be handling the media as much as I had here. Certainly during the case with Maggio making comments about an Academy Award winner. It started on a Monday with the press finding out about it. By Thursday, they were asking me to go on Good Morning America and things like that. So it turned into Reuters, The Guardian, and of course, her being from South Africa meant the agencies there. So I'm very, very respectful of the press. I don't know how can I protect the public if they don't know what I do? So usually our sanction letters,
good.
sanction letters usually speak for themselves. So I stick to simple quotes, sound bites, etc. I do consult with experts. I have some media folks in the print media and investigative reporters who I will ask advice on how to handle certain situations. Obviously, the case that I mentioned before with the judge having his child in the car was a big media explosion. How do I comment on that? Do I comment on that once it was public, or from our point of view? So those things were different. An example of how we use the media strategically was in the Bachman case. So we announced that he would not agree to the proof that we had. And we had some very scared individuals who did not want to testify against this judge in a rural area who had been in power for a long time and had done this for a long time, including while he was a prosecutor, and somehow got cleared by federal authorities for that. So we decided we go to charge them. Normally when we charge a judge, we would just release the charges to the press, get some phone calls and answer them. However, in this situation, we made a strategic decision that I would do a live press conference. I've never done one before. And why? Because in this case, it wasn't just grandstanding. It wasn't just an opportunity to talk about the bad judge. It was an opportunity to embolden some other victims. And I knew that if I stood there between the flags being asked questions, that some victims might call in and they might be like, okay, they're actually doing something about this. They mean to actually take this judge on. And in that situation, I did my press conference, I answered questions, and before I got back to my office, I was already getting phone calls from people who were calling in to say that they were victimized as well. So that worked. But most of the time, we try to stay factual, conclusions. We don't give a lot of opinion, but we are available to the press to explain what things might mean in a final action letter. Social media, we don't use Twitter to release documents. There are some that do. We probably will at some point. Beyond that, I would say that our social media would be pretty limited and we wouldn't want comments and things like that. So it would be tightly controlled. Balancing confidentiality. Obviously, I'm going to quickly go through this one. Investigative stage confidentiality is different. It's completely different than a shrouded process. So we're going to start off with it being that way. However, at a certain point, you either get a public answer, a public conclusion, or a public trial. So the private sanctions, there are a lot of jurisdictions that do private sanctions. A complaint comes in against the judge answers, and then the public doesn't get any answer, but the judge gets a private letter saying, don't do that anymore, we're warning you, etc. There's a big split on whether that's a good thing to do or not. A lot of Judicial Conduct Commission directors think it's a great way to train judges and help them and not let them get damaged too much. I find it difficult because the average citizen does not get that. If I get in trouble for a debt I owe, for a driving incident that I have, it's public. So that's an interest, a difference there. Next one is boosting the confidence of the judiciary while exposing misconduct. Simply put, I think we have to say it, and I say it quite often. The vast majority of judges serve with honor. This is not who we're after. This is what we don't deal with that except to help those judges, and we also don't repeat the error. So when Maggio has 3,600 improper online statements, we don't hide them from the public. But in my actual letter, which you can read if you want to look at the link, I only use a few examples because otherwise I'm telling the same off-color joke 3,600 times again. Or in a case where there was a judge running for office, he made rude comments about other judges. Well, I don't want that. The effect is now the public knows the jokes and put downs he made about other judges and affecting them. So we try not to repeat the error while still informing the public enough of why the issue is there. Now, in both those cases, you could go search for that stuff and find it yourself, but it wasn't going to come from us as, again, repeating the error. Techniques in gender-related cases. Obviously, these are different. I am very fortunate in that not only was I a domestic violence sexual assault prosecutor here in Little Rock when for about 4 years or so, but also both of my deputy directors that I've hired have been domestic violence sexual assault prosecutors. So we kind of came with that mindset of understanding how difficult it is for victims in these kind of cases. We've done a lot of collaboration about sexual harassment. I actually sat on a We Too panel by the National Association of Women's Judges at the U.S. Capitol in, I guess it was 2018. And I've spoken with some of those panelists about using their expertise to train judges and others about bystander training and other things to help us be able to look into harassment in the courthouse. It's not always the judges, it could be other staff. And again, the judicial workplace is a very private, close-knit group, so it can lend itself to some bad behavior, and we've seen some of that in the United States. We also reverse engineer allegations. We do that in all allegations, which is to try to put ourselves in the seat of the accused as if they had done something wrong. What else could they have done to cover it up and try to find those tracks backwards? That's no different than any type of investigation, but it's certainly something that we use in those situations. And finally, on the last slide of questions are, what are the recommended corrective measures or remedies for judicial misconduct cases? Well, first of all, there's written sanctions, and we hear about this all the time. Oh, all you did was send the judge a letter of warning. All you did was send the judge a reprimand or a censure. However, sometimes that is the appropriate sanction. First of all, not every violation should result in sanction. But when it does, there is something that teaches the judge and the rest of the judiciary these are things to avoid. I will say this, we have elections here. We had 3 judges run in elections this cycle. All 3 we had 3 run that had a sanction, a written sanction, a warning, a reprimand over the last 2 years. All 3 of them lost their election. So they do make a difference, and they are something that people can campaign against, or a judge could lose an appointment. We can assign a mentor or court monitor. Mentors are difficult because a lot of judges don't want to be the mentor and have to look after another judge, but it is possible. Court monitors, like if you have a demeanor issue with judges, you can send someone into the courtroom to monitor them. And then you can adjust a docket or case assignments. There are judges out there that have a difficult time with certain types of cases. As long as it doesn't affect the rest of the judiciary, you can make a change if you think that will help. Suspension without pay. Now, the thing about suspension, obviously, would be a serious offense to result in a suspension of a judge. We believe, and most of us in the U.S. community believe that if you're going to suspend a judge for longer than 3 or 6 months, you might as well have removed that judge because you're really just causing more problems for others, other judges that have to pick up the work or special judges that have to fill in. Therapy or rehabilitation. That case was that's okay. That example case was from the judge with the baby in the car, right? So he gets acquitted. He goes to trial. They don't convict him of negligent homicide. It's sad. Everyone's crying. Everyone feels bad for him. But I can't just allow him to go back on the bench without guaranteeing due process by the fact that he is mentally and psychologically able to do so. That he's gone through something horrible, much like a police officer in a shooting, or the kind of industrial psychology we do for astronauts or people in high pressure professions. We sent him to that type of psychologist. He was very, very cooperative the entire way. And until we had that clearance, at which point I did a letter. I think I've got that in my my links as well, that kind of explains here's why he's now able to go back to work. I guess that's pretty much where we're at. On the final thing I'd like to say, I guess, or final part I'd like to say, is if we're going to have a judicial conduct commission or a disciplinary body, it has to do something. In other words, it can't just opine. And I think my last quote is from Aristotle. Ethics agency must not merely theorize on proper or improper conduct, but must affect change or correct the conduct if able. And that's what we try to do. It's not about sanctioning judges or giving judges a hard time. It's about trying to affect positively change in the judicial community that I hope upholds the reputation of the judiciary. You know, the average citizen cannot be expected to brush off difficult or improper behavior by a judge. The power imbalance is too much. So that's where we stand in that gap. However, after 13 years, I've probably been here for the removal of 24 judges who have been removed from the bench and other sanctions. I would say I have a higher opinion of the judiciary than I had before I got here. The work that they do, the patience that they have, the types of training and investigations they have to do just to learn the subject matter, and the protection of the rule of law comes from our judiciary. And I really am thankful for that, and hope that by enforcing the standards against other judges, that I uphold the reputation of the ones that do their job with honor. Again, there's a lot I could talk about in general and more, but I hope I put a lot of references in there, and that there's a lot that you can talk about with judicial conduct commissions. But I do think it's important that we have some sort of check or balance, but that it's not there to interfere with the independence of the judiciary, rather to refine it and make sure that we do have judges who are worthy of the robe and will support the rule of law. So thank you very much. Again, it's a subject I really enjoy talking about because I've done it for many years. I've really enjoyed being involved with the network, and certainly hope to be able to contribute more in the future. I'm available for comments or questions. Roberta, if anybody has anything for me.
Thank you so much, David. This was a very interesting presentation. And I'm sure everybody's asking themselves who the award-winning actress is. But I think you've given enough hints to that. And I'm sure the records must now be public. So anyone who's interested may look for that information. We are now going to go through the questions in the chat. We already have collected some of these questions. For everyone joining us, please feel free to ask your questions using the chat function. Again, we kindly ask everyone to keep their cameras turned off and the microphones muted so we can guarantee the quality of the audio for everyone. And we have here already some questions. So I'll start with the first one, who was asked right in the beginning of your presentation. So, are the investigations secret and closed from social media?
They begin secret. So much like a federal grand jury in the United States, the grand jury meets, and in our case, it's called an investigation panel. And anything they take in is confidential up until the point they either decide to charge the, in which case pretty much everything is going to be public, or they negotiate a settlement. If they negotiate a settlement, all that becomes public is what's in the settlement. Now, that's where it's incumbent upon me and the Judicial Conduct Commission to tell the truth, to tell the story. And we need to make sure we tell the public enough about what has gone on. But up to that first part, much like a lot of police investigations, certainly in the United States, you cannot get the file until the case is done. So that's kind of how it works. In general, it gives the opportunity for the judge to not be blasted in the press or otherwise for mere allegations before they've even been vetted.
Okay, good. Thank you. So the next question we have is, do you permit lawyers to participate in the disciplinary proceedings?
Yes, we do. As a matter of fact, we encourage it. Now, you got to remember, we might get 300 complaints. A bunch of them are, we don't like the judge's verdict. So those go nowhere. Then we probably have, we're a small state, 3 million people or so. We may have 3 or 4 cases a month that have investigations that we have to do, actually look into things, get statements. If those are serious enough, I send what I call the lawyer letter, which is, hi, Judge, we've got a complaint. You might need to get a lawyer for this one, right? And they generally take my advice. There are others where I will tell them, look, I understand what happened here. Just write your response. Let's look at it. You're not at that stage yet. But otherwise, yes, they have a right to counsel, and their counsel can be here, and it certainly makes it easier. I love judges, but they don't always make the best clients sometimes. So I think that it makes it harder for us to negotiate directly with the judge sometimes. So we've had very good luck with the lawyers in our community that do this kind of work, and that open dialogue really helps.
Good. So the other question we have here is there legislation that provides for these investigative and hearing procedures?
Yes. We were created by the Constitution, and our rules, according to the Constitution, are to be promulgated by the Arkansas Supreme Court. So the Supreme Court set up not only our Code of Judicial Conduct, which kind of mirrors the Bangalore principles, it also set up the rules of procedure. And that's what I've talked about, our investigation panels and my dismissal power. All that stuff is in rules that came from the judicial branch, because we are part of the judicial branch. And they set that up. There's a lot of different ways you can do that, but that's how it came up. The legislature still provides our funding. So we have checks and balances. Like, I can't say I'm completely free of political powers looking at me either, because we get pressured. Every judge is powerful and political and has friends. But I have to get money from the legislature. I have to get appointments from the governor. I have to get rules from the Supreme Court. So it kind of balances itself out.
Mm-hmm. And that's why you have the separation of powers and the checks and balances. So all of these elements can really be equalized in the process, right? And maybe to add, you mentioned our paper on the gender-related judicial integrity issues. Thank you for that. But maybe another resource that we just recently developed and launched at the conference in Doha is also the guide on how to draft and implement codes of judicial conduct. Because a lot of the disciplinary proceedings really depend on the codes of judicial conduct or the framework for the disciplinary procedure. So for anyone interested, that's also another resource that might be very useful. So with this little piece of marketing, I have another question for you from the audience. Who appoints members of the commission, and according to what kind of procedure?
Excellent question. This is how we spread it out, and this is just our version. We have 3 judges, 3 lawyers, 3 normal people. The judges come from the Arkansas Supreme Court. They're appointed for 6-year terms, staggered. So every 2 years for a little while, so they stagger. And they can serve twice, so they can be reappointed 1 time. The procedure is simply, when they run to the end of their term, we tell the Supreme Court, you've got an appointment, they make an appointment. The 3 public members come from the governor's office. And the same thing, they're staggered. We have 3 years of appointments and then 3 years of no appointments is how it kind of works out. And the 3 lawyer members come 1 each from our attorney general, our lieutenant governor, and our speaker of the House. So you can see there's 5 different political entities involved. We contact them. A lot of times a new speaker of the House won't even know they have an appointment to my commission until I tell them. They look for people. We've gotten wonderful people on our commission. I have to say that they've done a great job. We've got everything from a law professor to we used to have a man who ran Ornamental Iron Works as a public member. We've had farmers, and we've had judges on all types of different courts. So that is kind of how we get them. And I do think that the diversity of appointing powers helps, because it's not like we get all of them from the governor, who could then put pressure on us because he or she appointed all of them.
Yeah. No, that's a very, very good point. Yeah, the diversity and the mixture that makes for another interesting checks and balance. Another question, do members of the disciplinary commission get any special training? If so, how many hours and who does it?
Excellent. Our best product for that right now is that every 2 years, the National Center for State Courts, Center for Judicial Ethics, has a college on ethics. And I'm, again, honored to be a presenter there with a wonderful, now retired judge from Washington State. We present every time on things like, what should the sanction be in this case, to help train commissioners who might be, like I said, a businessman. Not only am I familiarizing myself with the code as a businessman, now I've got to figure out what happens. What happens when a judge gets a minor criminal offense? They don't know until they go to these type of trainings. I wish it was more than every other year. We have recently, my deputy director has efforted trying to get a border state, in this case Oklahoma, to work with us, that every other year, we do something with Oklahoma where we do some training together. So far, we've been really, really lucky in that the National College has really trained all of our folks and well. It's a very, very good program. And some of our commissioners asked to go back, that they're like, I would go again to get that more training and more ability to look at stuff. Other than that, we provide them with information from the Global Judicial Integrity Network. I provided them information from the National Center on State Courts recently. We just make sure they have at their disposal things to review. They review national cases. We have the National Center puts out every 2 weeks what happened in West Virginia this week, what happened in Texas this week, and they get to see that as a review. Certainly, it's something that we want to make sure that we're investing in our commissioners as well, because even judges don't necessarily come to a conduct commission knowing a whole lot about the code and the procedure. It's a unique situation.
No, that's a very interesting point. And also to mention that Arkansas is one of the training sites for our judicial ethics training tools. So one of the latest additions, and we're very happy to see that the training is already being used by the jurisdiction. Yeah. For anyone joining us today, if your jurisdiction is not yet a training site, please contact us if you're interested in that. Maybe we actually have quite a number of questions for you.
Okay. That's okay.
Yeah, it's a very successful session. But please also let us know at what point you might need to resume your work for the day so we can finish the session. But we'll try to go through everything as much as possible. So the next question would be, what is your advice in situations where the judge being investigated finds many ways of delaying a proper hearing, appeals, objections, etc., and manage to delay any real action by, say, well over 12 years? That's actually quite a lot.
That is. Yeah, I mean, I think these are dangers that occur, particularly when we do not anticipate our rules not being able to handle this. So what we do, and this may sound like an unwieldy way to handle this, but we're in the middle of reviewing all of our rules right now. I've got some very eager commissioners. They're law professors, they're judges, and they talk about things they don't like in our rules, like the ability to delay, or there should be a time limit, or how come we can't get this case done quicker. And we had a case that blew up on us, I guess about 2 years ago. It involved special counsel. We were recused, but nevertheless, it resulted in dismissal because of a violation of time limits. What that does is finally get people to look at the rules and go, we need to change these rules. So one thing you've got, obviously, if it's that much of a delay, is you've got an issue where your rules are not containing that they did not anticipate a judge would be able to do so. Otherwise, the only thing you can do is the same thing you would do as a litigator, is continue to bring this in front of the body and we can continue to say, we need to get this to trial. As we know, I've spent my entire career with the burden of proof, right? I was a prosecutor, I've been an ethics prosecutor, and I was a plaintiff's lawyer in wrongful death cases. Time is not my friend, right? I need to get things to trial. Victims don't get, better memories over time. You definitely want contemporaneous facts. So in that situation where it's been that much of a delay, that's obviously something to do with the system that needs to be changed. But I don't doubt that your conduct body is trying to get it tried. It just sometimes you're going to have to keep fighting that, but that is a difficult situation. I don't like hearing stories like that.
Yeah, and I think it's also a problem, an issue shared by the whole justice system when you're investigating any misconduct, not only the misconduct of judges, but I think that's something that happens throughout jurisdictions, the whole of the justice system. Maybe another question. I'm also trying to combine some of the questions that might relate to the same topic, although the chat keeps moving quicker than me. So to what extent can judicial disciplinary bodies be involved in judicial misconduct that is of a criminal nature?
Obviously, there are aspirational parts of the code that are also in the Bangalore principles, and they would be simple. You got to follow the law, and that means don't get arrested and don't get charged with crimes. The vast majority of times, we're secondary. So the judge has already been arrested. The judge's actions are in the public, so we can wait. We can delay on purpose to wait to see what happens in the criminal case. That's not always been the case, though, during my tenure. I don't know if it's just bad luck on my part. But in the Bachman case, particularly, we have several police agencies here that told us there was nothing there. They weren't going to waste their time, which made us kind of the lead in an ethical investigation that I thought was really criminal in nature. So sometimes, that's what we had to do was we couldn't treat it like a crime. We just had to treat it like if you commit a crime, you violated the code. Bachman was a unique case, but there were others like that. We had a judge who failed to even file taxes for 20 years. We had judges who've gotten driving while intoxicated convictions, things like that. But if we can wait for criminal authorities, we will. But we also won't allow a judge to delay that way, because they can delay a criminal case for a long time, hoping to delay our case even longer afterwards. So there are times where we will make them make a choice and go forward. Again, it's a difficult spot to be in, but we do have the ability to refer cases, even the confidential parts, to criminal, audit, other agencies like that, lawyer discipline. So if we see things like that, we can refer it. So we'll work with them. Thankfully, I'm a former prosecutor, so are my deputy directors. My investigator spent 26 years with the FBI. So we've got a really good office as far as knowledge of how to handle criminal cases. So if we see something like that, we can either handle it ourselves as an ethical issue and see if the criminal agencies will come in after us, or we communicate with them and wait till we find out what's going to happen and then act accordingly.
And I think this also links back to the other question you answered about the type of training that members of disciplinary commissions should receive. So it should be a very comprehensive and sometimes holistic approach that really encompasses every type of investigation so that they can better handle the process, right? So we have one here about recusal and appealing. I try to combine here maybe a couple of questions. How do you deal with the recusal when an accused complains about a judge trying him or her? Can the decision about the judge be appealed in general, not only in this case? And specifically, have your decisions in the disciplinary commission ever been challenged in court?
Good questions. All right. First, the first part of the question allows me to also reference another good article, which is Cindy Gray, who is the head of the National Center for State Courts Center for Judicial Ethics. She did an article that is the seminal work on when does legal error become misconduct? Because as we've talked about, we want an independent judiciary, but obviously making decisions, if you were bribed, is improper. So it's not just about, you can't always be immune just because it was a decision you made. So when does it become that way? And recusal is one that stands on the line because, as you know, that is an appealable issue. So, judges decide, no, I'm not going to recuse on this case, it's not necessarily misconduct. It might be an appealable issue for that defendant to say, the judge knew me when I was younger, therefore he should have recused off my case. If that's just the crux of it, then we probably don't have an issue. That is a legal issue. There are times where judges don't recuse that are obviously within our rules, like involving relatives, things like that, that they should have known better. As far as whether our actions are appealable, yes, and they are. Again, the vast majority of judges never come in contact with me. They're good judges. The ones that we've had to take out, they sue me, they appeal me. My first case on the Proctor case I was talking about with the probation program went to the United States Supreme Court. They denied cert, so we didn't have to appear there. I argued from the Arkansas Supreme Court on that case. So yes, and they have been adjusted. And I would say that it happens, even nationally, it happens somewhat often that a judge might get a suspension, but the Supreme Court might reduce it a little bit or might increase it a little bit. So they certainly do look at them. So yes, and quite honestly, anytime we do a suspension or a removal, it generally goes in front of the Supreme Court. So judges have full due process rights and should. As a matter of fact, we've added parts to our rules. I've added parts that are not required of us to give extra protection to the judge because I believe we should protect their rights like anybody else. And so we've added that as well. And appellate, certainly. We have a lot of appeals, and if I'm not getting sued, I've probably had a bad year.
I think this also links to other questions that we had here. You touched upon circumstances in which legal error can be investigated as judicial misconduct. And I think this also links back to another work that the Global Judicial Integrity Network is doing, which is on the area of judicial immunities. So judicial immunities are an important part of protecting, safeguarding judicial independence, judicial integrity. But there are, of course, situations in which the judicial immunities cannot be used to shield judges from gross misconduct, gross mistakes, and really situations that are not in line with the judicial mandate. So I think you touched upon this, but I don't know if you'd like to add anything to this.
No, I think judicial immunity is absolutely a principle that has to exist. Otherwise, the judiciary is the weakest branch of government. It doesn't have armies. It doesn't have the power of the purse. All you have is the trust and confidence of the people. And you could certainly bog down a judiciary by continually suing judges over their decisions. You can't have it that way. That's why a Judicial Conduct Commission has to be limited as well. And again, I'm the director, and there are things that I don't want authority over because I don't think it's right. I think the rule of law is what we need. We don't need just an investigative agency that's job is to harass the judiciary. That's not our job. So yes, judicial immunity is very important, and it's very strong here in the States. As a matter of fact, Maggio, who I mentioned with the Charlize Theron is the actress, with that case, he was then convicted of bribery for reducing a verdict in a nursing home case later on. They have sued him, and he has so far been able to avoid that by judicial immunity, which is pretty amazing because you would think an illegal action by a judge you could get sued for, but it's still in the courts. But that's how strong judicial immunity is, that they're very reluctant to say you can sue a judge for a decision that they make. And that's correct.
Yeah. Yes, it is a protection for the judges. Yeah, we just need to be very careful when that should be lifted or not.
Yes.
So there is another question here on what would be considered misconduct. So does a parent incompetence ever cross a threshold to be treated as misconduct due to persistence or some other facts?
Yeah, that would be a difficult one, but we've had family issues, so to speak, that cross over. Now it's going to have to be more, we have agencies that look at misconduct by parents and how they raise their kids and things like that. We have had, you can get divorced. You can have a contentious divorce and it not be misconduct, right? I mean, judges have personal lives. and they don't get along, and divorced people don't get along normally very well either. So those things we will shy away from. However, there have been situations where, and I could think of a case recently that's not, just give generalizations on it because it's not quite public enough, but where it's possible there was a domestic abuse situation between the person and the spouse, and the kids were there. And so at that point, we're starting to get into a situation where it's affecting the public and the reputation of the judiciary, and then there's children involved. We might look into stuff like that. So certainly it's possible. There's a really good book called Judicial Conduct and Ethics. It's kind of like our giant book, horn book that we go to. And because there's not a lot of cases in each jurisdiction, because we have 50 something of them and we're all different, America's not easy when it comes to trying to figure out what all of us are doing. We look at that a lot, because I could probably look through that book and find annotations where judges got in trouble for something about the way they were treating their children. But, you know, it's rare, but there certainly are some limitations to your personal life.
Maybe now a question about another topic. So how do you treat or handle anonymous complaints?
We do, and we have accepted anonymous complaints always. We treat them the same way. So if an anonymous complaint comes in and says, judge is engaging in conversations with one party and not the other and giving an unfair advantage for these reasons, he does not, whatever, he does not like this person, he has business interests, whatever. Even if it's anonymous, we will send that to an investigation panel. The challenge would be, I don't have anybody to follow up with, right? So with a named source, at least I can go back to that person if the panel has questions and says, well, what do they mean by this that was in the complaint? What do they mean by biased against? How do they describe that? I don't have anybody to call because it's anonymous. So that's a little more difficult. We also have the authority, which I think is a very good tool for me to file complaints. So in other words, if something happens that's open and notorious, I don't have to wait for a complaint to be filed. I can file it myself. I filed the Maggio complaint. I filed several complaints because I knew that was going on. So anonymous complaints, they're a little more challenging, but we have actually, the Proctor case started with an anonymous complaint. We've had others that are, if it's empirical evidence, if they're saying Judge Smith is trying cases involving his nieces and nephews and should be disqualified. If that's anonymous, I can look at the docket sheet. I can find that out and know one way or the other if it's true. It doesn't matter if it's got a name on it. So some cases, it's not a problem. Others, the judge is mean and makes comments about people in court that are not on the record, but are racist or misogynistic in nature. Well, if you don't tell me which days or more information for me to go back, that's hard. I'm going to have to now put a monitor in there and hope that I catch the judge saying those kind of things. So those are more difficult.
Mm-hmm. Yeah. And would you have the obligation to investigate in case of an anonymous complaint that seems credible, or is there a discretionary decision there that may be justifiable, but is there a discretion to that, or is there an obligation to investigate?
There's an obligation to at least send it to a panel. The only dismissal authority I have is to dismiss cases not in our jurisdiction. So if they complain about a judge who's in the federal system, I don't have authority over federal judges. If it's a judge that has been off the bench for many, many years, we have a time limit. Okay. I don't have authority. If it's, well, the judge gave me 10 years and I don't think I deserve 10 years in jail, I should have gotten 8. I can dismiss that. We don't have authority over that kind of argument. But beyond that, within the realm of it being somewhat reasonable, I have to send it on. Now, there are some times, and I mean, not being insensitive, but we actually get complaints from people in mental institutions. So they may complain about something that's just completely off the wall, you know, aliens and blacked out helicopters and all kinds of things. I'll at least send it to a panel the first time. They'll dismiss it. If the person continues to file those complaints, I will not send them. I will not bother a panel or a judge with that. But generally, if it's in our jurisdiction, I send it on.
Mm-hmm. Yeah. So maybe this links to another question we have, which is how do you handle vexatious litigators that present claims solely to harass the judges?
Great question, and we have them. They we have a couple right now that have gotten to the point where I will not send their same complaints on because it's already been determined, right? It's almost like res judicata. We've already heard this. You're complaining about the judge. You don't like the ruling. And then they'll wind up suing me. Matter of fact, one of them just sued me just the other day. He sent me 700 emails in the last 18 months, right? There's vexatious litigants everywhere. At some point, normally it's about the second time around, I'll not make the judge have to respond to that. I will send it to a panel, maybe, have the panel look at it, say, this is the same complaint by the same vexatious litigant, and they'll dismiss it. We have discussed having a rule, because the federal courts here do have a rule on vexatious litigants. That's one thing we were talking about recently before the coronavirus kind of messed up some of our meetings. But we're going to be working on whether we would have a rule on that. So I think it's an important issue, and I think it's very forward thinking if you're looking at rules or a commission to have some sort of proviso for that.
Good. So we have a question here. It's a bit long, but I think it's quite interesting. In a close-knit community where everyone knows each other's names and where it's extremely challenging to maintain the anonymity or confidentiality, it is very difficult to get witnesses to come forward, particularly staff to come forward to testify against their bosses or employers. So what are the possible actions that can be taken in these situations?
You know, I've had different roles. As a prosecutor, I might have used a heavier hand at times with witnesses and crimes. We rarely use the heavy hand with our witnesses against judges. In other words, we don't threaten that they're going to get in trouble for not talking to us. We really try to work that trust with them the best that we can. However, there are plenty of staff members who are covering for a judge who is doing misconduct, so they're not going to be cooperative either. If that's the case, we'll have a strategy decision about the best way to subpoena them or make them go somewhere. I really think that is an art more than a science. It is an art of talking to these people, contacting them, know which ones are afraid, why. It's not easy. There are plenty of cases. Bachman had a complaint when I was deputy director, and we never got the information that we got 3 or 4 years later. It's just the dam had not broken yet. And the second time around, when my deputy director at the time was able to contact these victims, they were finally willing to talk. I think that's what you're going to face in certain situations, particularly in small towns where you have very few people. They all know each other. They're all in the same legal community or judicial community. Certainly, that's an issue that you're going to have to deal with. I wish I could give you a more concrete answer on that, but that is a challenge. It's 100% a challenge that we have to deal with. The only thing I would say is we rarely threaten them in any way, shape, or form. We try our best to gain their confidence. And I'm from the South, so we use a lot of strange sayings, but we call it carrying the water. And we'll say, like, you're not carrying all the water, right? So we're all in this. There's other people carrying buckets of water here, not just you. And if we can do that, I think it helps some victims sometimes to realize, I can't tell you what the other 5 people are saying, but I promise you're not the only one saying this. To kind of make them realize they're not standing out on their own. But beyond that, it's an art form.
Yeah, it's all about building trust with the witnesses and anyone reporting misconduct. And I think this also links to another question that we have, is that public trust and confidence in the judiciary is an important factor in the administration of justice and maintaining rule of law. Is there a role for civil society as a member of disciplinary bodies for judges?
A role for just society in general?
For civil society. I think that the question might be whether or not members of civil society could potentially be members of disciplinary bodies for judges.
Yes, we do. We include them, and we value their opinion. Because quite honestly, we all understand the legal process. But there are times where our people from civil society, our normal people, our regular members, will point out an offensiveness that the average person might feel that we as lawyers don't. I mean, judges disagree with me all the time. I've lost cases, I've lost verdicts. It doesn't, you can't take it personal as a litigator. But for my mother-in-law to get in front of a judge and have that judge be mean to her, that's a hard day. I mean, she's way powerless compared to a judge. As a lawyer, I can argue back, I can put things on the record. So we do need that perspective that comes from regular society, and we value their input. And we actually, the governor's office and others, solicit their involvement, and we involve them in our rulemaking. We try to, again, we're we're a third of each, a third of judges, a third lawyers, and a third civilian members.
So I know we are very much beyond our time. So I'll just give you 2 more questions, and then we'll finalize. For everyone joining us, we'll also later make available on the website the video of the webinar, including the question and answer portion. So how has the publicity of a judge's misconduct investigation ever affected his or her subsequent work? For example, what if an accused asks a judge to not try him because he had been sanctioned for misconduct in the past?
That happens, and we certainly have. It even happens when the judge has been removed. So Maggio was removed. Now you're seeing appellate actions by defendants saying, well, he was my judge and he was corrupt, therefore I need an appeal. No other reason, nothing personal about that case, but they try to bring that up. Certainly judges who are disciplined but not removed from office, because we're an election state, they're going to have to deal with that during an election process. Not a whole lot to say in a judicial election. We're not partisan here. In our elections, we're not supposed to use partisan tags in our elections. So you kind of run on, I'm a good guy, I'm a licensed attorney, and I've done a lot of great work. So if you have anything negative like a sanction, it's pretty damning. So it does do that. As far as major consequences, we've even had a few judges where, and it was negotiated, where the only way we were going to let up was that they agreed to never be in public service again, and that we had them sign that agreement and that we would sue to enforce that if necessary. So yeah, it can affect them further. However, again, most of the time, if it's a small correction, they're fine, or they finish out their career and do okay.
So one final question to you. We have a question here. I'll try to summarize. It's the relationship between the public being aware of the judicial misconduct body, being aware of the disciplinary body, and being more or less inclined to report issues with judges to law enforcement. So how do you promote what your commission does to the public to foster confidence in the judiciary and also confidence in reporting misconduct?
I think that's incredibly important. Again, the public is not going to feel good that the judiciary has accountability if they don't even know that we exist. We've made it our effort since 2007 to go to schools. We speak at large high school events. We've spoken to colleges. We accept invitations to speak at each of the law schools in our state. We go to the major bar meetings, whether it's the Arkansas Bar or the Trial Lawyer Association or Criminal Defense Attorney Association. I'm an ethics hour, and in continuing education in the United States, they have to get a certain amount of ethics hours. So we become valuable speakers. So we do that. And I think that it's really important. And again, another reason why I've been wanting to make sure that the public knows through our press releases. We removed a judge from office by agreement on May 1st. In that agreement, we release it to the press. I make sure that my friends in the press get that information and that the public knows about it. But I think you're absolutely right in that there has to be confidence in the agency in order for people to believe that the bad judges or the unethical judges that were removed that was correct, and that the rest of the judges are doing a very good job. And again, for me, a final comments would be, I know a lot of you are judges, and I just want to say you probably don't hear this a lot, but thank you for what you do. I mean, you hear a lot of complaints. You might get a bad letter from me, even if you're in Arkansas. But you don't get to hear the people who compliment you for the difficult job you do in supporting freedom. Without a proper, independent, virtuous judiciary, mob rules. And that's just the bottom line. And if fundamental law doesn't matter and the rule of law doesn't matter, then it's just the most popular people getting their way and bullying everybody else. And that's why the judiciary is important. It's the heart and soul of a free society. And we need the bones and the muscle too. We need the legislature. We need the executive branch. But the heart and soul of a free society lies in its judiciary. And I thank you for what you do.
Thank you. Thank you very much, David. And also thank you for ending a webinar on such a sensitive topic with such a positive note. Thank you for a very, very interesting session for discussing a very challenging topic for the future of judicial integrity. We know that many jurisdictions don't have the same structure as you have in Arkansas. There are a lot of issues still of disciplinary proceedings being used to exert influence over the judicial process. So we know how sensitive this topic is for judges everywhere. Thank you so much for adding your experience to the debate. So for everyone joining us, this was the second webinar of the Global Judicial Integrity Network on the investigation of judicial misconduct. Thank you very much for everyone who joined us. Stay tuned for the next webinars. The next one will be on 28th May on the issue of eliminating gender bias and stereotypes from the adjudication process. So you will soon receive a reminder to join us. And as I mentioned, the recording of this session will also be later made available on our website. Thank you all very much for joining us today. We hope to see you soon. David, again, thank you so much for being with us, especially being so early for you at this time. So I hope you have a nice day today. And for everyone, please continue to keep healthy and safe, and have a nice day or end of the day for those ahead of us in the time zones. So thank you very much, and until the next time. Bye.